One of the things that is very clear is that, not this diagram, but what's very clear is that if somebody dies without a will, there is going to be a probate, most likely, because that means there's not any other estate planning done. A probate, I'm sure we've all heard of really a lot of horror stories about probates. This type of situation, dying without a will, is one of those horror stories. So I am going to share with you such a story that is going to show why it's so problematic to die without a will and how costly it really can become. So this is a matter of public record. So I am not sharing with you any private or confidential information. For those of you in the Spokane area, you may remember a jazz musician from decades ago. His name was Billy Tipton. Billy Tipton, upon his death, it was discovered that Billy was a female. And so that was something that was pretty sensational around here many years ago. Well, Billy Tipton was married to Kitty Oakes. Kitty Oakes was, so Kitty is the wife and Billy is the husband. They had 3 children. Kitty Oakes never had any estate planning done. And she lost her capacity, her ability to manage her own affairs. So she became a ward of the state. As an aside, I'll say one of the reasons you want to have an estate plan in place is if you do ever lose the ability to manage your own affairs, your powers of attorney will have appointed somebody you trust to manage things. Kitty didn't have that. So she became a ward of the state with a certified professional guardian appointed to manage her affairs, both financial and personal. What happened next? Well, as you can imagine, she hadn't done a will. So when she died, her estate was probated. She didn't have a will, her estate was probated. She's not married, so you think, okay, well, this should be pretty easy. Didn't I say that she had 3 children? That's what it appeared, that she did have 3 children, three sons, 3 boys. But what we learned through this probate process was that none of those boys was considered to be her legal children. How is that? None of them proved to be biological. We had DNA tests. None of them were legally adopted. They came to the family without going through legal channels. Yet, all of these boys were, by any definition, definitely children of Kitty Oakes and Billy Tipton. From any way you look at it, they raised them. This was a family unit. This went to trial. I was the attorney for the estate. There were attorneys for each of the sons. So there's 4 lawyers involved. And we were litigating questions such as, are you a biological child or not? Are you legally adopted or not? With no one agreeing on anything. So there were a lot of litigation fees in this. And it went to trial in front of the Honorable Michael Price, who is one of our judges here in Spokane, just an outstanding judge and jurist. What he did was he was faced with the decision. What do the laws of intestacy say here? Well, let's assume that these boys weren't legal children. In that situation, what we had to do was we had to look at, okay, who did Kitty leave for her surviving family members? She wasn't married. Kids, we'll get back to the kids, whether or not these kids were actually going to be seen as her legal children. And if not, you had to look up to grandparents. She had none. And then you had to go out and go down to her cousins. and there were cousins in Kentucky. So they were also part of this litigation because we had to give them notice that you may inherit from Kitty's estate. It went to trial, and what Judge Price did was, and this is not a reported decision, by that I mean it wasn't appealed up. Nobody appealed the decision because I think all of us who were involved felt it was the right decision, was that he said, Judge Price did, that there is a doctrine called equitable adoption. And looking at all the circumstances, maybe this wasn't a legal adoption, maybe these weren't biological kids, because they weren't, but for all intents and purposes, the court was going to recognize her 3 sons as being equitably adopted. And by virtue of that doctrine, they were given the standing, the position of legal children. So Judge Price's decision allowed these 3 boys to each inherit 1/3 of Kitty's estate. Personally, I think that that was the right decision. I think that that took a very good judge to reach that decision. But you can see, I think, how easily the estate could have gone to the cousins in Kentucky, because a judge who was not Judge Price might have reached a completely different decision. So in that case, it was the right outcome. It took probably about $100,000 in expert fees and legal fees, et cetera, to get to that point. And her estate was worth about $300,000. So about 1/3 of it went to legal fees, which is proving what I'm trying to tell you is if you don't have a will, you don't know what's going to happen. Other than we know it's going to go to probate, most likely, and there's going to be a lot of legal expenses and a lot of hurt feelings. See, these 3 boys in this case weren't really happy to be in the limelight about their family's situation. She could have just done a will and it would have said to my 3 sons equally and named them. It would have gone there. We never would have known about this case. But she didn't. She didn't do her estate plan. She was under a guardianship. And that was the result, was this case. This case was actually so interesting to the media that the Investigation Discovery Channel did a 1-hour show on it called The Will, Family Secrets Revealed, because it was a sensational fact scenario. I think it's kind of ironic, or at least misleading, that they titled it The Will, Family Secrets Revealed. It should have been, There Wasn't a Will, Family Secrets Revealed. Had there been a will, we wouldn't have known a lot about what happened. That is probably the most poignant example of what can happen to a family if there's not a will. It was very difficult and devastating for the boys, her sons. Not something I would recommend to anybody to have to go through that.